Our next speaker is Tony Lathrop. Tony is with the North Carolina firm Moore and Van Allen. He's both a corporate trial lawyer, also a certified mediator, so he can both try your case and get it settled, particularly if he's the mediator. And one of his interest areas is helping clients develop strategies to optimize trial results and to reduce litigation risk across the company. He's here this morning to talk about the new hurdles and rethinking what is possible in the area of class action. So, Tony Lathrop.
I want to thank our leadoff hitter, my friend Joe Krasovic, for teeing up the Giorgio Armani piece for us. It was actually a class action involving Armani and Speedo, so I've got about 8 slides on that case. I'm going to talk about the Concepcion case, which came down about a year ago, but raised as many questions as it answered, and give you all and try to give you some good takeaways for you to use internally with respect to your arbitration agreements, because that's one of the key areas of the Concepcion decision. It's especially important if you sell goods or services to a broad base of customers, or obviously if you've got a lot of employment agreements. Here's a hypothetical, just an example. Say your company is a temp agency that places temp employees. You've got a lot of contracts with temp employees, and they file a class action against you and other temp agencies for price fixing. Here's another hypo. Say you supply goods, baked goods, including special recipe muffins to stores and restaurants, etc., and you've got a definition of a special recipe, and there's a class action for false advertising. So how to try to prevent these with your contracts and agreements? The class arbitration waiver. And the Concepcion case was all about a contractual class arbitration waiver in a consumer cell phone agreement. And there's an arbitration clause that you see in a lot of those agreements. One of the cases leading up to Concepcion was the Stolt-Nielsen case, and it starts to outline a policy favoring arbitration. That case provided that a class arbitration can't be ordered by an arbitrator if the parties didn't agree to have class arbitration in their agreement. The agreement was silent, and so they said the arbitrators can't write that in. And so the Concepcion case continued that trend from the Supreme Court, and that was decided about a year ago. There was a class action by cell phone owners alleging false advertising, and the contract, the allegations were false advertising. The contract established an arbitration procedure and precluded class actions or class arbitration. So the district court held in favor of the plaintiffs and denied the motion to compel arbitration. They held that that provision was unconscionable and that the defendant AT&T hadn't shown that bilateral arbitration adequately substituted for class actions, quote, deterrent effects. And that's purportedly an artist rendering of Mrs. Concepcion, though I'm not sure it's when she saw the slide of Giorgio Armani or not. The Court of Appeals affirmed the district court and elaborated, saying that that contractual provision was unconscionable under a state law rule in California. And that Discover Bank rule, essentially, the court indicated that that was not preempted by the Federal Arbitration Act because it was a, quote, refinement of the unconscionability analysis. Now, I'm not sure what the heck that means, but sounds official. That rule, that state law rule, provides that the class action waivers are unconscionable where the party writing the contract with the waiver has superior bargaining power. Now, at the Supreme Court, it reversed the Court of Appeals in favor of AT&T and essentially said that the Federal Arbitration Act trumps that state law rule. And it says that, in the FAA says that the agreements can be invalidated by generally applicable contract defenses, but not defenses that apply only to arbitration, i.e. that Discovered Bank rule. And so, and that's the point I just made, that the Discover Bank rule is not a ground that exists at law or in equity for revocation of a contract. More on the court's analysis of the Federal Arbitration Act and the Discover Bank rule. So the purpose of the FAA is to ensure enforcement of arbitration agreements according to their terms for streamlined proceedings. Finally, they said that class arbitration, to the extent that it's manufactured, which is a strong word, by Discover Bank rather than consensual, interferes with fundamental attributes of arbitration. And the switch from bilateral to class arbitration sacrifices arbitration's informality and makes the process slower, more costly, and more likely to generate a procedural morass. And in particular, when you start having thousands of plaintiffs in a class, but then you put it in arbitration where there's limited rights of appeal, the stakes get quite a bit higher. And I think that was part of the thinking. I'll add that a California case, just an update, a Court of Appeals case last week issued a decision providing that Concepcion also trumps California case law ruling that class waivers in employment contracts are unenforceable. So that creates a split that's probably going to go to the California Supreme Court and maybe further. That case, if you're so inclined, is called Iskanian, and it's 21 Cal App Lexus 650. For a quick update there. So, what does all this mean for us? Consider drafting and revising your contracts to include binding arbitration provisions that preclude class arbitration. Consider including similar provisions in your employment contracts, your collective bargaining agreements. Although, as I'll get to in a minute, there may be some limits on that. Where possible, and this is a real case-specific thing, if you can, in a case, you may try to reopen it or get it reheard if now that Concepcion has come down, it's more favorable with respect to class arbitration issues. Consider including provisions in class arbitration waivers that provide for the company to pay some portion of the arbitration fees, including associated attorney's fees. And this will help head off an argument that individual arbitrations are cost prohibitive. And I'll note that the contract in Concepcion actually made it more beneficial from a cost standpoint to bring individual arbitration, and provided for a floor of recovery of several $1,000s for plaintiffs who prevailed, as opposed to the class action, which would provide for way less than that, maybe under $100 for a plaintiff, for the class plaintiffs that stayed with it. So, as I alluded to, there's some limits on Concepcion that are working their way up through the courts and will probably wind up at the Supreme Court within the next couple of years. If you follow it to its logical conclusion, it's going to lead to only individual resolutions of a wide variety of claims in arbitration. And that's just, there's all kinds of legal challenges to that concept. In a lot of ways, it is a green light for using class arbitration waivers. However, there's, as I'm going to discuss, there's a significant possibility that class arbitration waivers aren't going to apply across the board. There's possible exception situations with fair debt collection, mortgage servicing, insurance contracts, fair credit are just some examples. There's a possible preemption, ongoing preemption issue. Consider whether there's legislation, in particular federal legislation, which prohibits arbitration. And vindication of rights, where there's statutory provisions, especially federal statutory provisions like the Fair Labor Standards Act, for example, that come into play. With respect to vindication of rights, the Supreme Court and circuit courts have established that agreements to arbitrate statutory claims might be unenforceable if the terms of the agreement prevent vindication of statutory rights. And there are several sites there, and a couple of those I'm going to talk about, especially Greentree. In the Mitsubishi case, the Supreme Court held that an international agreement to arbitrate was enforceable so long as the prospective litigant may effectively vindicate the statutory cause of action in the arbitration. And this is the Greentree case where the court held that potentially an arbitration agreement could be invalidated on the ground that individual arbitration would be too expensive. Although in that case, the court found that the plaintiff didn't make that showing. And lower courts have begun to prescribe how the principle of vindication of statutory rights will be applied to class arbitration waivers. There's several factors that they're going to consider, looking at the nature of the claims. Are they federal or state claims? Is there a particular statutory scheme that requires class or collective procedures to be available, like the Fair Labor Standards Act, or whether a plaintiff would pursue claims in the absence of a class because of the small value, as I alluded to in the Concepcion matter. Some cases, some courts have dismissed Concepcion as not controlling where the statutory rights were federal because Concepcion only addressed state law preemption, as I mentioned with the Discover Bank rule. Substantive areas where Concepcion might be limited or prohibited are Title VII cases, Clayton antitrust claims, and as I mentioned, FLSA claims. And some courts are saying that the statutory schemes require class or collective procedures. One of those cases, the Goldman Sachs case, is a Title VII case. And the Southern District Court in New York refused to compel arbitration, even though the employment agreement contained the class arbitration waiver. The court reasoned that because the pattern and practice discrimination claims are prohibited by being brought individually, that compelling arbitration in the face of the class waiver would require a forfeit of that statutory right. AT&T versus Fisher is another one. Whether to issue a preliminary injunction preventing compulsory arbitration on the basis that an antitrust action under the Clayton Act is by nature a representative action was the issue. And AT&T argued that the waiver prevented class arbitrations and pursuing the representative actions in court. In that case, the court granted the injunction preventing compulsory arbitration, but ducked the issue of whether the class arbitration waiver would be valid if taken to the extreme. Another key case is the Citigroup case involving a Fair Labor Standards Act claim. And the plaintiffs were looking for uncompensated overtime. And there's the provision of the arbitration agreement saying that claims must be brought on an individual basis. And the holding was that the waiver of the right to proceed collectively under FLSA is unenforceable because it involves a substantive statutory right. And they went on to distinguish FLSA waivers from waivers of class actions. And there's a couple of statements there about why and how they made that distinction. So, what next? Other courts are also reading Concepcion to validate class arbitration waivers, and contrary to what I was just saying, there's an Alabama case for Mr. Sharman where a lower court held that arbitration could be compelled in connection with an FLSA claim. And the National Labor Relations Board recently ruled at the agency level that class arbitration waivers in individual employment contracts that prohibit class arbitrations are unenforceable because they prohibit the exercise of the substantive rights under the National Labor Relations Act. I'll add that that case has been appealed and is going up to the Federal Court of Appeals and is being briefed now. So one of the big questions is involving, and I alluded to this with the Green Tree case, is small value and prohibitive costs. And my red light has just come on, and so I am going to, in accordance with the orders of Ed Chalet, I'm going to have to stop and commend to you, I've got a good number of slides. They are all in the manual that you have there, and discuss some of the nuances and other areas where Concepcion may be limited, and ultimately what you in your seat can do to take that into account and take advantage of it with respect to your contracts. So I'm sorry for running over, but I thank you for your time.